escape.
Okay. Well, our technical staff back there, are we back on? We are? All right. Good afternoon, everyone. What a great morning. I am Bob Rapp. Here at Case Western Reserve, I teach our securities regulation courses as well as business associations and also law theory and practice in financial markets. Now, our second panel today brings three particular perspectives on the role of private ordering, in imposing order on the business of a corporation and in regulating its affairs and the rights of shareholders, or in some cases, those who would be shareholders eventually. And you've already briefly met the three scholars who will present this afternoon. Professor Robert Thompson joins us from the Georgetown University Law Center, where he's the Peter Weidenbach Junior Professor of Business Law, and he will present today on the topic of contracting out in the 21st century. Corporate law, for which he will look very broadly at the ability of parties to change or opt out of contract around corporate law rules via private ordering, with a view to developments involving public companies and contrasting approaches in the close corporation and LLC settings, and also considering the circumstances when it is or it should be appropriate to do this in all of these settings, and what are the limits of that. Professor Anat Alan-Beck is our colleague here at Case Western Reserve. Is a widely recognized scholar on emergent issues and private ordering involving a special breed of corporations identified as unicorns, those large private companies about which she has written so extensively and about which she will present today on how bargaining inequality and equity award information asymmetries have led to some troubling results in contracting around and waivers of important statutory rights. Professor Gabriel Rauterberg is with us on screen today from the University of Michigan Law School. He enjoys wide recognition for his scholarship, not only in contract law, but also the empirical study of corporate governance. He presents today on property, contract, and process in organizational instruments, and the ways we think about contracts in private ordering in organizational governance, and the central instruments through which such governance is constructed, and the process by which they work, all to provide a functional framework in dealing with some tough questions about contracting and private ordering and corporate law. And what a privilege it is to have these three scholars who will share their work. And so we're going to get started straight away with Professor Bob Thompson. We'll continue the format from this morning and provide time at the end once we have all three presentations for comments and questions. So Bob, the floor is yours. Welcome.
Thank you, Bob. Thank you for staying around. I'm delighted to have an audience. Can we get the slides? My topic is called Contracting Out in the 21st Century Corporate Law. The goal is to, it overlaps some of what you've already heard, but there's a different take, and so perhaps it'll open some reason for a discussion. And then what's the advance button? Jill, how did you?
Just enter.
Enter. Thank you. So just to map where I would like to go, as you've already heard, there's been a dramatic shift in contracting out in recent years, and I just want to emphasize that and illustrate it with a couple of examples. I want to look at it in different contexts, in closely held corporations, in VC-backed startups, and in public corporations themselves. The last two benefited from the work of Professor Fish and Professor Ratterberg, who's somewhere on that screen. And we've expanded the discussion of contracting out compared to what it was a decade or two ago, and that's worth focusing on. The second point I would make is that all of this, all three settings, is a distinct change from prior law. Our view of contracting out is not what it's been historically in corporate law in the United States. Third basic point is that there are different reasons for contracting out in each of those three categories. And plus, I think we can add the contract contracting that Jonathan and Juliet talked about, which is actually maybe a subset of publicly held. I haven't decided where it exactly goes, but there are different reasons, and so one size is not going to fit all, and we ought to be specifically debating that. And then the real question is, Jill had a bunch of should questions. Here's an answer. There are limits that should remain. I mean, that's my perspective. And just to go through the first three very quickly, the visible shift and closely held. We haven't mentioned LLCs hardly at all today. They now dominate the closely held space, and they are about contracting out. At least, I mean, ELF is one of the first, or one of the early Delaware cases. It says that the purpose of LLC law is to give maximum effect to freedom of contract. Now, you should know that was a 1999 opinion. It was pretty recent policy change, because up until check the box, it wasn't about contract. It was about tax avoidance. Then until check the box, it was mandatory. But anyway, that's where LLCs are, with lots of contracting out. You should also keep in mind, and it's important to me because I've spent some time in my career on closely held corporations. They were at it they were at it before LLCs. And with contracting out, and particularly 7.32 of the Model Business Corporation Act, which dates till into the 90s. And the official comment to the MBCA, this is a key sentence. It says, this contracting out that was in the 90s, it validates virtually all types of shareholder agreements that in practice normally concern shareholders and their advisors. So contracting out is broad and closely held. And it's been around for a while. Secondly, in terms of the visible shift that's happened recently and publicly held, it goes back, just to go through it very briefly. We had mandatory rules until fairly recently, not just from corporate law, but some of it happened from the New York Stock Exchange, but it's part of the reality of publicly held corporations. You couldn't depart from one share, one vote. When some of the companies started putting pressure on the stock exchanges, the SEC stepped up with 19C4, and then the DC Circuit pushed back and said you can't do that. This is part of the contracting out in public health, but this is where, to me, the modern era starts in this discussion. 102B7, 1985, exculpation for directors. 122.17, renouncing corporate opportunity is exculpation. It's interesting, that's in the charter, and Jill has written about this, didn't talk about today. It's in the charter, or by action of the board. Now that's a weird phrasing in terms of contracting out. And I think we've left contracting out and gotten into something else when we start letting the board do that. And then the last point I would raise in terms of thinking about contracting out in public corporations in terms of history is that cleansing is part of the history of contracting out in public corporations. It goes way back to Delaware 144, which says that if you have a conflict, you can cleanse it by actions of the board or by actions of the shareholders. And if you know your history, you know it was not void or voidable solely because it was a limited contracting out. It is expanded through case law and case law, and so. But it's part of the point is this line has been going on for a while, that we've been moving toward contracting out in publicly held corporations for 30 years or more. And it's part of where we end up, which is where I want to get to. To shift to the third category, the visible space in venture capital startups, Those enterprises are private, but they're not private the way closely held are, which is 2 or 3 shareholders. They have a larger number of shareholders, and they don't have the same intimacy in a closely held corporation because they are not working at the shop all day. They have an investment, and so you will get a different kind of contracting out in that setting. There is some trading of shares in venture capital startups, but it's not the public market. That changes the risk dramatically, and so that changes how far you can go in contracting out. Is part of my thesis. There has been greater use of contracting in that space to vary voting, to limit appraisal rights or inspection rights, to govern forum selection. All those things show up in this space, and as Gabe has shown in one of his papers, a substantial number of new public companies carry forward these different rules into the public space, and that underlies part of what Jill has written about in the past as well. So the answer is this is a pretty dramatic change that's been going on, and we ought to consider it against that context. But I want to contrast it to the history. The history is this is more dramatic than you might think. Go back to the beginning of corporate law in the United States. Before the founding, in the early 19th century, we had mandatory corporate law. Why? Because the sovereign gave a corporation whenever it wanted. Now there was some negotiation, but it was mandatory law from the sovereign. What I find interesting about early corporate law history is in the early 19th century into the middle 19th century. Well, look, go back this way. At the time of the founding, all the things that corporations didn't have. They didn't have limited liability. They didn't have centralized control, majority rule. They didn't have immortality. They didn't have lock-ins. All of these things became part of corporate law in the 19th century. And they were done because government was convinced of the benefit of corporations with these extra characteristics and gave these characteristics. And this is going to, I'm going to come back to this point in a couple of slides, but that's important to how I understand private ordering. If you look at the post-industrial revolution, the later 19th century, what you see is general incorporation had become the norm. That changes why you might want to contract out. Laissez-faire became from New Jersey in the 1890s, and then Delaware after Woodrow Wilson went to Washington. That is part of contracting out. The point I would add about history is into the 20th century, there was hostility to contracting out, big time, in U.S. corporate law. How so? There was firm law against sterilization, another word for contracting out, of governance, that you couldn't change the mandatory basis of the law into the 20th century. There was what was called the fiduciary norm, and if you changed it, there was no authority to change it. If you look at what was the 141, which is the key law in Delaware the 1927 Delaware law said businesses will be managed by the board. What's significant about that? There were no outs. There was no contracting out permitted. Now you can do it, and even now you can do it in the charter. But if you look at 141A, the only way you can amend 141A today is by the charter. Now, Jill has written about how you can do some other things by shareholder agreement, and you can do corporate opportunity by the action of the board, but there's still things in the 141A, which is letting directors do everything they want, that can only be amended through the charter. So there's this history of resistance, and McQuaid versus Stoneham is the key case that I still teach for contracting out. Now, I want to talk a minute about those three categories, but talk about the different justifications for it. Wrong button, let's try that one. If you look at the explanation in closely held, what I want to convey to you is why did we let contracting out occur? Because of necessity. What was the necessity? The default rules of corporate law were centralized control in the board, majority rule electing the board. Who does that hurt? Anyone that's not a majority. Who is that? It's all but one person in the closely held corporation. The corporate rules were not workable for most closely held corporations, and that's what motivated contracting out. It was a necessity, otherwise it wouldn't work. There would be oppression, and that's the justification for contracting out and closely held. By the mid-20th century, it was solidly established. It's gotten more established in the late 20th century, but it's different than what you see in publicly held corporations. In publicly held, you have to go find a different justification. Now, there's a prelude here, and I want to just shift your thought for a moment. The reason for all of corporate law was how much legislatures and the public felt like that corporations were good for society. And it goes back to the British and Dutch East India Company. They could do things that other people couldn't do. And so contracting out is related to this idea. And I want you to keep that in mind as we go forward. How might contracting work in a private setting? I think you have customization as an argument. Go back to closely held for one more moment. If the only people that are involved are at the table, you don't have externalization, and that's always. And if legitimacy, if otherwise you get screwed, you can justify private ordering. You still have the insiders know best in a publicly held corporation, but you also have a greater potential of externalization because not everyone's at the table. The other shareholders or the other creditors or whatever. In public corporations, I think contracting out is related in part, and this hasn't been talked about today, that internal governance will misfire, that shareholders will not have enough information. They will not have the proper incentives. They will be disruptive of governance. And so we let there be contracting out in part to deal with that misfiring. In that sense, and then you get the externalization further that Jill has already talked about, and these terms come in part from her writing. Oversight, transparency, standardization are benefits to the collective enterprise that come if you let there be contracting out. So there are different reasons. If you look at contracting out in VC-supported startups, you get a different criteria still. I'm using Gabe's example from his earlier writing on GoDaddy. What you have there is a founder and two sophisticated investment funds. That's a different relationship that you'll have different contracting out. The usual corporate law rules of centralized control and majority rule are not going to work. There's a little bit of necessity as well. There's also incentives, but there's also possibly for externalization. And if they go public, then you got a bigger externalization. So you have to look at the different examples in all three. I want to add one more point. I think this debate that hasn't been mentioned today, I think this debate is about, is broader than what we've just done, and it's contractarianism. And you remember that where Jill started her presentation with that picture of that law review from 1988? That's important for explaining why we let there be contracting out. I'm older than Jill. I was there for that, but I just want to share part of it because it informs. I mean, I just got tenure. I got tenure at 12. I mean, it was a child prodigy. What can I say? It still is vivid in my mind because what it was this fight that we're doing, the discussion we're doing today between enabling mandatory and contracting out. And Mel Eisenberg was the chief reporter for the previous ALI project. He was the author of the main corporations casebook. He was on one side, and the other side was Fred McChesney. who was a professor at Emory and was a law and economics person. What was astounding about that conference is, and it was mostly an establishment, but Easterberg and Fischel were there and some others. It was the directness of the challenge that contractarianism raised for the first time at that conference. Fred was brutal in taking on McChesney. He called him, names that would. He talked about that Eisenberg had stacked the deck in the coercionist favor. You're a coercionist, Mel. But it was worse than that. It became a. If you think this political dispute in America is bad today, in that room on that day, corporate law was that. And what I want to tell you is that that's part of the debate about how far we go in opting out. You have to have that sense. I got longer stories that I'm going to skip for lack of time. My point is it's about going back to Eisenberg and McChesney. It's about corporations. Either you trust corporations or you trust government, and you pick sides between them. Contracting out is affected by not just those incentives of my prior slides. It's affected by your political view of the world, and you have to take that into account, I think, in deciding what the right answer is. If you put it in those terms, there's lots of reasons for what do you trust government or not. I haven't got time to tell you about Stephen Field in 1886, but it's a wonderful story. I think you can't. Stephen Field thought corporations were the greatest thing for America that's ever happened. That's an exaggeration, but that's the direction. That's important to saying. Do whatever works for corporations, including let them opt out. He's not worried about the abuse. Anyway, the story is better than that. I think if you look at, this is an aside, but if you look at this trust of corporations doing the right thing, it's more pervasive than you ever thought. Poison pills is an example, which you may not think about, but if you think about should you be able to change the rules for tender offers? Well, a tender offer doesn't have the one thing that all the rest of corporate law has, of director veto. In a merger, directors can veto. They can't veto a tender offer. So what happens? This is an anomaly that Chancellor Allen talked about. That how did law get this? And then Chancellor Chandler said it's an anomaly that we have this form of takeover that doesn't have directors at the central place of corporate law. And why do we do that? Well, so we came up with a solution. What was the solution? Private ordering. We trust private ordering so much that we let law firms come up with this Rube Goldberg contraption, which is what a poison pill is. That has no explanations. I spent yesterday, 2 days ago, with my students just blowing their mind. They have no idea where it came from, why it works, because we trust private ordering to come up with the answer to the hard questions. So that affects how far we're willing to go. I could go on federal securities laws and ESG, but I don't have time for that either. This is my last big point, but what I want to argue is that where we are today about what should be the limits, there are limits, even in Delaware law. This is Obiad versus Hogan, which is a Chancery Court decision from 6 years ago. This is how Vice Chancellor Laster poses the question. He says there is a purely contractarian view, go back to McChesney and Eisenberg, versus a not purely contractual view. And he says in doing that, the primarily part is important. Is it primarily a creature of contract? And what he says, Laster goes back and says, if you have externalization, you can't have a purely contractual view. You have to leave room for mandatory rules. He actually says the debate over whether it was purely contractual, the permissive side, it was resolved by Section 1104 in 2013, which said you can eliminate, but within limits. So the point is that even now we have limits. I just want to point out LLCs one more time. If you look at what Rukla says, it says an operating agreement may not eliminate fiduciary duty. That's how it starts. And then the statute has except if not manifestly unreasonable. Well, that's opting out, and who knows what it means. There haven't been interpretations of that. But it does say, and this goes back to Jonathan's point about procedure versus substance, it does say you can identify special categories that are not violations, and you can provide for reasons for cleansing. RUCLA also says you cannot opt out of oppression. So the point is that you see this, but there are limits. Delaware, there are limits. So this is really a question of framing about how much limits can you have. The last thing I would say is that as OBED puts the test, it's always a question of what are the limits and what's the opting out you can do, which is a lot, but there are always limits. And those limits, if you go back and look at footnote 2 of last year, those limits are fiduciary duty. That's what he says. And fiduciary duty has always been the limit on opting out, and it's still there even though we have reduced it. The last thing I would say is if you look at case law, there is a ton of case law in which opting out has happened. And guess what? The Delaware Chancery Court has to interpret it. And the Delaware chancellors don't hold back from interpreting it. And these are just 4 examples. Adlerstein versus Wertheimer is a corporation with dual class in which you can't change fiduciary duty. VGS versus Castile is the same kind of case with an LLC. You can't change fiduciary duty. Fisk versus Partnoy, the LLC adopted corporation governance in an LLC, and that means that you are governed by fiduciary duty. OBED versus Hogan, the case I mentioned before, you adopted a corporate governance, and guess what you get? You get Maldonado Zapata. Not many times you get Zapata, but you get it in an opting out context. The point is, this is a dramatic, big limit on opting out, along with the statute and along with the traditional fiduciary duty. The bottom line is that we have corporate governance limits. I went too far, so I'm done. My water here. No, that was my double cup is mine.
Oh, great.
You can have it.
Thanks, Bob. That's just fascinating. The historical perspective, especially, is so interesting, and thank you for doing that. Equally fascinating, always, is Anat's work and presentations relating to the world, the kind of interesting world of unicorns, and private ordering is a very significant issue there, as you know from her work. Anat, please, we welcome you
so
as
much.
always.
Thank you. So this is great. Thank you so much. I'm taking notes throughout this conference. This is amazing. It's my favorite conference so far. And I want to present to you this project that just honestly, today I'm like, okay, I can write 5 more papers on this topic after everything I just discovered. So I'm going to, Julia, your notes. I'm over ambitious always. So I want to share with you a little bit of what's going on. What I'll do is I'll present my research question, then I'll set the stage. I'll give you a little bit of an overview of what's going on in the background, and then I'll go back to the central issue. And the interesting thing, and I've been tweeting about it today as well, because as you know, Elon Musk is going to be really laying off thousands of employees today. And reporters are, commenting on this, and they seem to not realize that there's several rules that are going to apply. We have the WARN Act, we have state, federal laws, contract laws, And the nice thing about this project, it's large. It's part of a larger project on unicorns, and unicorns are private firms that are worth over $1 billion. And I like to think about them somewhere in the middle, just like Bob presented, right? They're not like LLCs or other closely held firms, and they're actually closer to quasi-public companies, but they are privately held. And so there's a few more things that are interesting, and it affects the bargaining inequality here. And that is one, it's very well documented in the finance literature, and that is that they are overvalued. Okay. Just a second. Yep, it's not working for some reason. Let me try again. Okay. And so first, we have this shift in equity ownership. What do I mean by that? Today, more money is raised in private exempt markets than in our public markets. So we've had this shift in our economy, which I think is very important. And this is really a part of this shift that I'm going to try to convince you why this phenomenon is so important. This is the increasingly crowded unicorn club. So about 12 years ago, if I told you that there's a company that's private, that's VC backed, and it's worth over $1 billion, you would think that I'm crazy. But today, we have, and I monitor them, close to 1,000 companies that have this status. And some, today, it's funny, they're actually trying to avoid that status because I guess it also comes with bad reputation. And this is with regards to the unicorn overvaluation. This is from a model. There are two professors at Stanford, Strabulaev and Gornal, and they realized that unicorns are overvalued. And not only that, they even came up with an app where if you are a startup employee in one of these firms and you want to try to figure out what your company is worth, you can provide information to their app, okay? So they have an incentive here, right? They want you to provide the information as much as you can. The problem is the lack of information, right? We have an asymmetry of information, even though you're an employee, which means you're an insider, and I'm gonna discuss that in a second. Are you really privy to information? Is it the same as a startup that has 3 employees, where you're in a startup that can have 10,000 employees, right? You might not have the same kind of information as employees and closely held startups have. And so, so what's happening is that employees in these large firms that are privately held, they don't have access to fair market valuation or to financial statements. And in many cases, not only do they not have access, but they are denied access to such reports even when they ask for them, okay? And this is a very important development for 2 reasons, okay? One is, remember, they are still private firms, which means they don't have an exit event. Even though we have these secondary markets, most of these firms put restrictions on their employees' ability to trade their stock. And for a good reason, I have to say that. That is something that I documented in one of my first papers, which is Unicorn Stock Option. If I was representing the firms, I wouldn't want employees trading their stock, if they exercise it, of course, on these platforms, because then the company is going to be subject to potential violations of securities laws. Okay? Now, let me just explain a few more things, and that is that unicorn employees are usually granted equity in the form of stock options, okay, which is a promise of equity. They would have to exercise to become shareholders in the future. And it's a substantial part of their compensation, okay? And unfortunately, because we're talking about very large firms, they are in an inferior position to other types of employees. For example, senior employees, such as in the ones in the management positions or founders, or also sophisticated investors, right? Because the others will have information rights and they would usually bargain for them, or they would be privy to information that these employees do not have, okay? And what I've been documenting is that the firms, these unicorn firms are really suffering some reputational harm as a result of their practices. I'm going to explain the practices in a second. Their employees are complaining on public platforms like Paysa and others that they do not have access to information. There's information asymmetry. They cannot exit. They can't, then they're stuck with the firm. They have these golden handcuffs. Why is this important? How does that relate to our conversation? The interesting part, and it's funny because now I'm talking to a lot of Delaware attorneys, they weren't aware of the fact that also our federal laws are affecting what we're seeing today, and that is, so following the Jobs Act, employees don't get information that they used to before. So before the Jobs Act, they would count employees towards shareholders of record. And the second thing is that they used to get information on valuation and other types of financial information, and that was changed in the Jobs Act. So under our federal securities laws, these firms are not required to provide employees with information. And what's happening is that if you're an employee, and we need to really separate between early hires and late hires. Early hires are the ones that are stuck with the firm. They're the ones that have a lot of money on the table, especially, and they are not going to compete. And late hires diversify. They come in later after the firm already became a unicorn, and they're the ones who are jumping from firm to firm. They'll stay for a year, they'll exercise some of their options, and they'll move on to the next firm. And those are the ones that were recently hired, and those are the ones that the firm wants to retain. So this is also very problematic from the firm's perspective. Now, this is also very important. I've had conversations with this. People told me, well, why do you want to treat employees as investors? They're employees, they work for the firm. Why do they need to make an investment decision? And I tell them because there are several situations where they will need to make an investment decision. For example, if they want to leave, or even if they stay with the firm after 10 years, according to our tax laws, the stock options expire. So they have to make a decision on whether to exercise their stock or not. If they want to leave, the same. They have usually 60 to 90 days where they need to decide whether they're going to exercise their options or just leave them and move to the next firm. And that is a decision, and that decision, if they decide to exercise, is going to have tax consequences. So if they decide to exercise, they will have to pay taxes on profits that never materialize. And it might never materialize. And we're talking about a lot of money. We can be talking about millions of dollars. They have to mortgage their home. They have to take on loans. Okay, and let me give you an example with goods technology, right? Goods technology is always a warning sign. There was a fire sale in the company, and now with down rounds, I think we're going to see more companies going through that, especially now with the way our economy is doing. And in goods, there were employees that exercised their options. Not only did they exercise their options, they went on to secondary markets and they bought more stock in the company. Nobody told them that the company was going through financial difficulty. There was a fire sale. And the way it works in industry, and I'm very much aware of that, when a company is sold, they take the preferred stock into account. Common usually doesn't get anything. So these people who ended up paying large amounts of taxes, they end up paying to work for this firm because they got nothing after the sale. Okay, these are really sad stories, but they happen, and I have a feeling that today we're going to find more of these stories happening again because of the down rounds. And then I came across Professor Gill's paper on shareholder agreements, and I was fascinated, especially when I read about information rights in the employee context, and immediately I started researching the topic, and I said, okay, this is interesting. Now there's a new contractual innovation. Corporate lawyers figured out that we don't have to provide disclosure to employees anymore, to our securities laws, and so let's think about something. And I read an article from 2006 from the Wall Street Journal that said there's an obscure law in Delaware I love that title, right? You see journalists that never took one of my BA courses, right? There's a section that's called 220 that none of us have ever heard about. They said, well, I know about 220, right? I teach about 220. And so what does 220 do, right? If you're a shareholder in a company, it allows you to open up books and records. So anybody who's a corporate lawyer and is familiar with 220 and doesn't have information rights and has a client that wants to know whether they should exercise the rest of their options, what are they going to do? They're going to exercise 1 or 2 shares and then make a demand on the company and ask, open up your books and records. I'm a shareholder. I have this right. This is a private company. I want to open up books and records. Domo is actually a Utah firm. Today it's public. But at the time it was private. And what did Domo said? No, I'm not opening up the books and records. So of course there was a lawsuit. This lawsuit, by the way, was in Delaware. And the parties eventually settled. And so I asked, and Delaware was kind enough to send me the transcript because of the settlement. They're not public. And I wanted to see how the judges take information rights into account because again, let me just say one more thing about Section 220. You have a right to open up books and records, but it's under proper purpose. You have to show that you have a proper purpose. And the question is, if you want to know what your value is, right? If you want to be able to value your equity in the firm, is that proper purpose? And the reason the parties settled and they didn't want this transcript to be public is they didn't want the judge saying, of course, if you want to value your stock and it's a privately held firm, this is going to be proper purpose. And let me move this forward to a contractual innovation that I found, and I'll show you some statistics of what I found afterwards. But lawyers discovered 220, Wall Street Journal continued to cover the story, and corporate lawyers decided to come up with a waiver, okay? A waiver of statutory inspection rights. Let's make employees sign a waiver that until the company goes public, they will not have access to inspection rights, which means they are not going to be entitled to open up books and records. And I started seeing memos on this, and I'll even tell you it's even more serious than memos. I even saw the NVCA put it in their formal documents, okay, in their standardized documents. I'm going to explain that in a second. And I was just curious to see how prevalent is this practice. Again, we're talking about private firms. And so what I did is I started looking at companies that had already gone public, tech companies that had gone public, and I was looking for these waivers in these companies to see how many of them adopted them before they cleaned, because again, after you go public, you cannot have that waiver anymore. So it's only until the period where the company goes public. And I found this uptick since the Domo case. You can take a look here, where these are numbers of public tech firms that had these statutory waiver provisions in them following the Domo case. Now, let me just say a few more words on why we have this. That is because we have a gap in the literature. And that gap is very clear with the Jewel case. I'm going to get to the Jewel case in a second. And that gap is, so Section 220 is mandatory. And I'm trying to convince Delaware courts and the legislator, please respect the fact that this is a mandatory provision. It has a reason, and I document in my paper what is the historical reason for the inspection, right? Again, we're talking about a private company. It's also meant to mitigate against mismanagement. And it's a very important right for shareholders, especially in the context of privately held companies with the asymmetric information that I specified before. And there's actually a case now before Delaware. Chancellor McCormick is supposed to discuss this, so she wouldn't comment on this when I kept asking her in public, so what do you think about 220? Do you think it's mandatory, or can we contract around it? So there's a gap. We have this mandatory section, but which you cannot waive in the bylaws. You cannot waive that in the charter, but we do not know. Delaware has not made a decision on whether you can go around this provision in private ordering in a contract. And where I see that is that I see companies ask their employees to waive it in the stock option agreements that they're signing, sometimes after the fact, which means they just get, I've been interviewing employees just to see how prevalent this practice is. Sometimes they get an email that says, just sign this amendment. They're not even getting the amendment, okay? I never did this. When I was in practice and we did this, I always sent them the agreements. I always knew they're not represented. Most employees are not represented. They'll just sign anything you give them. But now they're not even getting the agreement. They're just getting this, like a link. Click on this that you just agreed to the fact that your equity compensation has been amended, which I think has issues also with contract law. I mean, I think it's pretty awful when you have parties that are not represented. Now, in Juul, there are some other interesting questions. Let me just quickly say what's happening. So this is a California firm. And let me just show you a few things. So this is, I mentioned this information in my paper, and I'm working on additional papers on this. So Juul is a California firm that's incorporated in Delaware. And the lawyers of the employee in Juul went to California court. Why did they go to California and not to Delaware? Because in California, 220 is absolute. You don't need to show proper purpose, okay? And that's how I teach 220. I don't know how other people in the room teach 220, but to me, 220 is not part of the internal affairs. It's an exception to the internal affairs doctrine, which means that if you're in California, if the company is headquartered in California and you are an employee in California, you can ask to open up books and records in California. In Juul, Delaware is saying, no, 220 for the first time is part of internal affairs. What it means to me, a California judge doesn't have to respect this. We'll see. I think it might even go up to the Supreme Court. And so in Juul, Delaware is saying, no, 220 is part of our internal affairs, which means you have to respect Delaware law on 220. And I checked how prevalent is this case. Do we need to worry about this? And as you know, and I'm showing this, I looked at the unicorn companies. 56% of them are headquartered in California. 89% are incorporated in Delaware. Okay, so this is pretty significant. What it means to me, we might have a wave, especially now with the down rounds of litigation on these cases. And in Juul, I read the opinion over and over, and there are several footnotes. In some of the footnotes, the court is stating cases to support the fact that 220 should be mandatory and cannot be waived. In other footnotes, they're saying, oh, maybe you can waive them in private ordering, but they're not reaching a decision on 220, whether you can waive or cannot waive in private ordering. And they said, oh, this is not a topic for this paper. We're only discussing internal affairs. We'll get to it later on. So now is later on, and I'm curious to know what's going to happen. This is just a little bit more of empirical data. I'm showing the industries, how prevalent it is in different industries. And let me just say one more thing about this waiver. It was common before in the biotech industry for different reasons. It was just adopted by corporate lawyers in this context now of the unicorns, of the tech unicorns, okay? This is a little bit about the language, and I have some suggestions for the courts, for the legislators, and for practitioners. I think, which I don't know if the legislator is going to listen to me. They might not, because the trend has been actually away from mandatory, of respecting mandatory rules, but to allow more private ordering. What I'm asking the legislator to do is to take stock option holders into account, not just stockholders, and to give them some of the protections in 220 and allow them to access information rights because of this asymmetric information and because of, as I'm showing in other papers, there's a lot of fraud in these companies because actually Elizabeth Pullman has a great paper on startup governance where she shows that there's a lot of problems in the governance, and I'm building on that and showing that many times founders now have dual class in these firms where they get to control the board, they get to control the decisions, and they don't represent common anymore. Thank you.
So many questions behind there. Why? All right, thank you. Our tech staff has Gabe Rotterberg up to join us remotely from, as we would say here, that school up north, correct? Welcome, Gabe. It's
Welcome.
The floor is yours.
Can you hear me?
Yes, we can.
Wonderful. Thank you. Well, thank you so much to the organizers for having me, and my apologies for not being here in person. There is the standard amount of baby food on my dress shirt, so that provides the explanation for why it's difficult for me to get out of the house these days with my 9-month-old. But I'm so delighted to be here. You know, it's a wonderful conference. I very much appreciate getting to see Jill's wonderful remarks this morning and Case Western for putting this on. And I'd like to thank especially Bob Thompson for introducing me to the wonderful term coercionist. I'm not sure whether I'm a coercionist, and I guess I'm gonna invite you to help me mull through these things. So the project, which is really just thoughts, they're various thoughts I've had over the last couple of years thinking about the issues we've teed up. It's called Property Contract and Process and Organizational Instruments, because the main theme of what I'll talk about is that they're two different, quite different, but worthwhile perspectives on the central instruments of organizational governance. And they both have a lot to say to us, but they can often pull in different directions. That makes thinking about the normative issues in designing organizational governance instruments extremely complicated. And you know, that's just par for the course, I guess. So what are organizational instruments? They're important. They also vary in fundamental ways across organizational forms. So obviously the corporation has the charter, the bylaws, and the shareholder agreement. The partnership has a partnership agreement. The LLC has articles of organization and operating agreement, trust indentures, etc. And recent years have seen important issues arise concerning the limits of private ordering as to these instruments, especially in the context of the corporation. And recent Delaware case law has pushed this issue to the foreground. It really has been asking the question, are rules of corporate law we took to be mandatory actually still mandatory, and if so, in what sense? So, you know, it's actually kind of more complicated than we thought, because maybe they're mandatory as to the charter, you can't non-consensually alter them through majority of inaction, but maybe you can consensually alter them, say, through a contract or shareholder agreement. But one of the things I want to emphasize, and I'll get back to this in a few slides, is it's important to keep in mind that while I think this is the main debate we've been talking about today, and it's an incredibly interesting one, namely the debate about should there be mandatory rules in instruments of governance, there are actually a bunch of other pretty first order issues that arise in deciding how a legal system should design an instrument of governance. So a little background, you know, two projects in particular took me to finding this issue as important and interesting as I did now. One was Eric Talley and I looking into 122.17, which Jill and Bob have already mentioned, in which Delaware authorized corporations to renounce corporate opportunities should they so wish. And Eric and I, you know, these slides are much more fun, of course, because they're Eric's slides from our project together a while back. But what we found was that there was a huge uptake amongst public companies, hundreds, if not well over 1,000 public companies that had adopted some form of corporate opportunity waiver. The other project that took me here was studying shareholder agreements, contracts amongst the owners of a firm that can sometimes in the public company context typically do involve the firm itself. and that are used to tailor features of firm governance. Now, in the shareholder agreement paper that I first did, I really focused on what I took to be the core governance contribution off those agreements, which were contracting over fundamental features of control, over who will nominate individuals to the board, over whether the company will support those directors, voting agreements in which shareholders contractually commit to vote for another shareholder's designee, and veto rights that are vested directly in a shareholder over corporate action. I continue to think these issues are really of great interest. In some sense, they allow a corporation subject to such an agreement to opt to contractualize politics, right? Insofar as shareholder voting matters, it makes it subject to contract. But what I didn't think much about, there are only, I think, a page or two in that agreement, was this issue that's really come to the foreground, which is, should you be able to waive mandatory seeming shareholder rights through a charter amendment or through a shareholder agreement? Just a few other questions about governance instruments. A different question than should there be mandatory rules. Actually, I actually added this to the slide. So Bob asked, I thought Jill a great question during the opening keynote, and it was a question I take it in the shadow of Bernie Black, right? So the ghost of the great paper, Is Corporate Law Trivial, is still out there. And I want to debate as much as the next person, should there be mandatory rules in corporate law? But of course the question is, if we have allowed as much private ordering in the country as we do, 50 jurisdictions in which you can incorporate multiple different entity forms, how much hangs, Jill noted, there's a lot of standardization. Now, you might wonder, that's an emergent property of an incredible amount of private ordering that we've enabled. So I do think it's a wonderful debate, and I completely agree with Jill that in some sense you want to bracket the question of, what you could do through another entity, so we can actually squarely address on the merits the question of should there be mandatory rules in corporate law. But nonetheless, I want to acknowledge that ghost of Bernie's paper in the background saying, well, how much does this debate matter? And I think that's always worth keeping in mind. A couple of other motivating questions about instruments of governance. So there's some basic questions are, what should the instruments be able to do and why? And these are good questions not only about the corporate charter or shareholder agreement, but about any instrument of governance in any organizational form. And as I'll try to discuss, one thing that I think Jill calls structural integrity has to do with what you might call informational externalities. Like we're making governance really complicated. Well, then it may be imposing costs on third parties, or maybe imposing costs on investors as an entire class. And that might mean we want to have some serious limits to private ordering here. Bob mentioned the East India Company, so I tossed in some of my favorite images. I've actually spent the last few years in part looking at private ordering in the first business corporations in England, the joint stock companies. So here we have the corporate charter of the Hudson's Bay Company and a contract from the East India Company. This is really just, I didn't have any fun pictures, so I tossed these in, but they're beautiful images of private ordering from 30 or 50 years ago. Okay, so all right, on to my main topic. Here are two perspectives on governance instruments that I think are important and valuable and that we need to take into account in addressing core questions about how to think about what should be permitted in these agreements and how they should be designed. So the first is thinking about these instruments as falling on a continuum between property and contract. Property, and by property I mean an instrument that non-consensually alters the rights and duties of non-parties to the agreement. And so I think I take the corporate charter to be property-like in this way. You don't have to have consensus. You don't personally need to agree to the things a corporate charter does for them to alter your rights and obligations as a shareholder or creditor in fundamental ways. And I take the shareholder agreement queasily to fall into the contract bucket for contractual instruments, insofar as generally courts have treated the shareholder agreement as only being binding as to the party of that agreement. So that's one perspective on governance instruments. that I want to talk about and think is quite valuable. And I think it's basically a Hansman Crackman-esque. Obviously, I think Henry and Renier introduced this debate to corporate law, at least in their classic article, The Essential Rule of Organizational Law. The second perspective is it's also important to keep in mind not just that governance instruments alter the rights and obligations of parties, but also that we should focus on the process through which they are created and changed. So governance instruments not only differ in whose rights they can affect, but they also differ in the process through which they are adopted and changed. So a shareholder agreement differs with the charter not only in its consequences for non-parties, it also differs in who can create it and who can change it. So the property versus contract is basically the question: does the instrument bind third parties? Some instruments do, others don't. The process, I think you can basically decompose process into two principal elements. The coalition of actors whose involvement is necessary to adopt or alter an instrument, and the decision rule, the formula that set of actors that coalition must follow to effectively act, say majority rule or unanimity. To make this slightly less abstract, you can compare process in the shareholder agreement and corporate charter, and what's the coalition, what's the set of actors necessary for a change to the charter? The corporate board and a vote of all shareholders. Now, Jill noted, really intriguing, because I never thought about this at all, but I would have written this differently if I thought of it. Jill asked the question this morning, could a corporation in principle decide that it wanted to eliminate through its charter the necessity of a board veto to alter future charter amendments? I guess I just, in my DNA, I've so assumed that the Delaware courts would not allow that I've never asked the question. But depending on where the courts go, that could become a question. Anyways, for the rest of my remarks, I'll be assuming, with that proviso caveated, that the corporate charter can only be created and changed through the joint action of a majority of the board and a majority of all shareholders. Whose action is necessary to adopt or change a shareholder agreement? Well, only the shareholder parties to that agreement, and the corporation if it's a party to that agreement. What's the decision rule? Well, the default decision rule for adopting or changing the corporate charter is a majority vote. So the majority of directors or the majority of shareholders, that's a default. I think it's a mandatory floor, but it's default in the sense that you could later supermajority rule over it. And then for shareholder agreement, again, the default is unanimity amongst the parties. So all the shareholders have to agree, though that too is a default, as most things in contract land are. Okay, so what are some key functional, what are some key functional considerations here? Like, I've sketched these two perspectives. I'm not there, so it's hard for me to know whether I've gone too slow or too fast, but hopefully I made sense that these are both valuable ways to think about governance instruments. They reveal illuminating functional elements of them in different ways. And so how can they help guide normative analysis? Well, a couple of examples. So property versus contract. I think this should matter to us when we ask a bunch of questions. So how easy should it be to alter a governance instrument? Well, it depends on the costs imposed on third parties. So this is just a sort of ceteris paribus, everything else being equal argument, and Jill might disagree. And I really disagree with her with great caution. But I think presumptively we should be more willing to allow complexity in a shareholder agreement than complexity in a charter, because I think there are fewer informational costs. There's less dismantling of structural integrity when you add complexity to a corporate governance through a shareholder agreement to a charter, because at least insofar as the shareholder agreement is only affecting the parties, that's a big question, right? Because some shareholder agreement things affect third parties, potentially. But insofar as it's only affecting the parties, well, the parties are all subject to the contract. They know exactly what they're signing up for, versus the property-like consequences of a charter change, which impose on all of the millions of revolving shareholders of a public company the cost of having to figure out the informational complexity of a more opaque corporate governance. Okay, process. I think the key question for the process distinction between the charter and shareholder agreement to be, when is a board veto appropriate? And I think that too is a useful question to ask. Like, the board has an element of it, which is it can be an agency cost itself, and the board has another phase in which it does a bunch of useful things. So it can mediate amongst competing constituencies. It can provide advice. It can be an impartial check against an overweening controlling shareholder. So I think there are a bunch of functional considerations that come with both of these perspectives. Okay, so let me quickly try to conclude here. Some preliminary conclusions. Optimal governance instrument design depends at a minimum on combining both of these considerations. If an instrument binds non-parties, you're going to want to think about process differently. And what kind of process you have, whether you want to include a partial check, like the potential involvement of the board veto. So that's one preliminary conclusion. I think that we really have to combine the property contract continuum perspective and the process perspective in thinking about how to design the instruments of governance and what to permit and what not to permit. And the second preliminary conclusion is the set of I just mentioned this. The set of persons affected by a governance instrument affects the efficiency of deviating from the familiar default arrangement. So the informational content of the default charter is undermined by a tailored charter, but it's not as clear to me that the informational content of what we associate with the corporate forum is undermined by a shareholder agreement. So let me end things there and turn it back over. But again, thanks so much for inviting me. I'm super excited to have been involved. I found it immensely interesting to listen to Anat and Jill and Bob. Thanks.
Thank you so much, Gabe, and to each of our presenters this afternoon. Sure. Would you? We have time for questions and comments, and the invitation is open. Jill, yes.
So there's so much in all of those three great presentations to ask about, but let me try and start off with something very simple, because Anat, I agree that the whole Jewel case is fascinating, and there's also this really complicated procedural history and the race to the courthouse and race judicata and all of that stuff. But let me ask you, what if California decided that it should provide shareholders with inspection rights as part of California consumer protection law? So here I'm drawing a little bit on the Women on Board statute, right? We don't necessarily have to do it through corporate law. And something that I've always wondered is whether the Women on Board statute really is trumped by the internal affairs doctrine. But, California employees who are shareholders presumably are an interest of California from a consumer regulation perspective, right? So would that work?
That's a great question. I've been thinking a lot about it, and I think it's even a little more complicated because when you're doing business in California, you also have to be a foreign corporation, right? If you have a certain amount. So to me, just by being just two things. One, by being a foreign corporation, I think California law applies to you first.
Well, and Grove argues that in Jewel.
Exactly.
And Delaware hasn't recognized the validity of California 1601.
Correct.
But 1601, even though it's foreign corporation law, it's part of corporation law. It's not about something else.
Yes. And so I think in this case, I would personally, my view is that California law does apply. And if you don't want it to apply, then be headquartered somewhere else. But I think that here Delaware is really, interfering in the laws of the state of another state. And with the example you gave, it's even more clear that I do personally. I think that that should apply to the company. But that's again, Delaware disagrees with that. And
Well,
they might disagree with that example as well.
wouldn't that law arguably fall within the intra-corporate affairs, the sort of middle tier in Cookie?
Well, that's a new, I need him to be able to come here and explain the inter affairs to me first before I can answer that, because I'm not sure that I understand what that means. So, or perhaps Delaware can give us a little more clearance on what is that exactly, because I'm not sure what it is. But that's, I'm waiting for some more clarity on that.
Do either one of you see that Jewel changed Delaware's approach to jurisdictional coverage of corporate affairs? I mean, they've been solid for a long time that California has no place in determining Delaware corporation law.
Well, yeah, but that's, again, part of the challenge is California has recognized the validity of forum selection provisions that choose Delaware. So Jewel has a forum selection provision. The Delaware court interprets something presumably under internal affairs, right, because it's inspection rights, right? And then the California court says, okay, this is res judicata.
Exactly.
That doesn't seem to really get at this tension, right? It doesn't really seem to be properly presented.
Yeah,
Right. I think we're not there yet, but we're going to get there.
We're going to get there. And now it's also conflict of laws issues, right? And I also think that it might go up to the Supreme Court because, California can decide what they're deciding. Delaware is deciding clearly something completely different. And corporate lawyers are saying, what do we do? Yeah, so that's really an interesting development.
I think your consumer affairs question is actually more interesting, but maybe that's because I'm writing off the internal affairs. I mean, California's going to differ from Delaware, and that's been true since the 1950s. And if anything, Delaware's gotten more adamant in its views, and it hasn't made any difference. And then for the women directors, the precedent, even though it's based upon California constitutional law, it's not so encouraging for California exercising its right against headquartered companies on it.
Well, I don't really see either of those decisions as even
but it hasn't.
considering that question.
No, but it hasn't precluding it, but it hasn't decided it.
Right. Yes.
Yeah, and an interesting discussion would be on fiduciary duties here, right? And the duty of oversight. And are we going to see the same? I've been pushing Delaware to do what they did with Caremark with regards to that, to expand that. So that would be interesting to see if Delaware will follow California and do that or not.
So where does the current Supreme Court come down on California versus Delaware? I don't know, but it would surprise me. I mean, it would be an arresting change if the U.S. Supreme Court takes a case and has to decide whether or not to enforce Delaware internal affairs law or California laws on operating headquarters in California. I don't know how this Supreme Court has which fight they have, which dog they have in that fight, I guess.
I have a question. I'm not sure if it's for Bob or not, or Gabe, but this is related to something Bob and I were talking about just as we were walking back in. When we're thinking about opting out, and we think about provisions that affect governance, could the charter say something like, actually, the board of directors might give their proxy for voting at the board meeting to either somebody who isn't a director or to like a corporation? I mean, there's this literature on whether entities can be directors. Like, can we contract around this sort of fundamental idea that we want the board to deliberate and we want the board to be comprised of the humans, elected by the shareholders? Or can we instead include in the charter provision that says, well, actually, we can contract out for that as well? Is that a mandatory provision? Is board deliberation mandatory?
We could take a poll of this group.
Pretty small group.
Yeah,
Yeah.
but even so,
But it's science.
what are the mandatory provisions of Delaware law today? How long would it take us to come up with the list? What I told Jonathan as we were walking in is that it would seem to me to be a dramatic shift if Delaware, which is so committed to the power of the board and the power of the board being collective and the power of discussion between board members, if they would say that you could give proxies to a non-board member as if it were a agency proxy right. I just that would be a conflict with the conception of what Delaware says boards do, but.
Except there is the shift in the language of 141A, right? So it's not, it used to be the case that it was the board and only the board.
And now it's
As
broader.
may otherwise be provided in the charter.
Well, yes, and I wanted to turn your attention to a nice paper on something similar. Not exactly that, but a good friend of mine, Sergio Alberto, wrote a paper on AI. And whether you're familiar with that paper.
That was my next question about was, well, what if we just give it to the algo?
Yeah.
Does
So
it have to be a human at all?
in the U.S., I think the answer, and I agree with his paper, is no. They're discussing it outside the U.S. and they're making decisions on that in Australia and other places. But I think in the U.S., the answer to that question, I agree with his analysis, is still no.
I haven't read the analysis, but why is it in the U.S.? Isn't it in Delaware or some specific other state? And they might be different, but what's the theory that says we let machines decide? I mean, we don't have. I mean, so we pass we have an amendment to the articles to the certificate of incorporation in Delaware that says we're gonna operate the corporation the way that Bitcoin operates its DAO, and we don't need people. Machines can do it as well. Does the current language of 141 let you amend the article to say we're going to be like a machine? And boy, that seems like a reach.
Yes, and I just wanted to build on that my interpretation is those are actually partnerships. So they have unlimited liability, and that's why a lot of lawyers are now coming up with all these wrappers that they're doing, which is also a very interesting development. Yeah.
I had questions.
Yeah, go
Yes,
ahead.
please.
Okay, I wanted to follow up apropos of what you guys were just talking about with a question for Bob, which is, I agree with you that as a descriptive matter, the role of the board and the fiduciary duties owed by the board remain, despite the nipping flux of Delaware precedents in the last 10 years, kind of a hardcore mandatory content. And I'm sympathetic to virtually all of that remaining the case. Nonetheless, as a wholesale comment, I'm not sure I agree. And so, Bob, I'm wondering if I wanted to ask you, if the year was 1999, and you were being asked whether 122.17 should be adopted, what would your response have been? And just to fill the question, Eric and I in the paper, I think we have a relatively happy story of how you can alter some pieces of the fiduciary duty of loyalty, and it can be good for firms. And we have some empirical evidence that supports that. And in the years since that paper, I thought that the duty of loyalty is actually quite a variegated domain. The terrain includes a bunch of different things. And some of it, it's very hard for me to come up with a plausible efficiency rationale for ever allowing people to contract over it. But maybe one or two other things I could think of something. And so the question is sort of do you think of the duty of loyalty as being one homogeneous thing and we should not alter it at all? Or do you think there's some parts that might be potentially contractable or we should allow parties to contract over?
we've already done it, right?
Yeah,
You
no,
don't
but
think-
do you support that?
Oh,
Do
you
think
say
that we should have it?
1999, in 1999,
Or
would I-
do you think that was a mistake?
There are two questions. I would say in 1999 it was a mistake,
I agree.
but the question is, how much room do we give to make mistakes, and how much do we say? Because most of what contracting out is a balancing question, to say what are the relative risks, what are the relative risks to third parties, what is the relative risk to how corporations run, if we move this mandatory rule. And the risks are going to be different for each decision. And so if you were to ask me, would I say it made sense to permit opting out of all fiduciary duties? No. Would I do it on a one-off basis? Maybe. And I would make the decision on one-off. But I think, look, I teach three things in corporations, and I say I'd even start now in the first day of class. Delaware has three rules. Rule number one, trust directors. Rule number two, shareholders do only a few things, three, vote, sell, and sue, each of them in limited doses. That's the fundamental concept number two of Delaware law. Number three, we rely upon fiduciary duties because we don't trust agency costs that come from the first two. I think that describes corporate law. And because I think that, because I'm committed to that as an orienting rule, I would be, to remove number three would fundamentally change what Delaware's been for all of my life and 3 lives before that.
And that's why I'm having a hard time with the cows and the other developments that we've had. You know, I mean, and we'll see what's going to happen next. I mean, now with inspection rights as well. I mean, are they going to? Yeah. I mean, are they going to continue with that with regards to inspection rights? And if inspection rights, which are so fundamental, think about it, in private companies, you don't even have liquidity. There's really no. First of all, I don't think they're insiders the way they call those employees, because they're not. When you have 10,000 employees, you're not an insider. You don't know what's going on. You're not management, okay? But second of all, it's such a fundamental duty. Once we start, taking that away, what's next? What's really next?
Since we've gotten all skeptical about contracting in the public company, Bob, I want to take you back to where you started your talk, and that's the closed corporation. You and I, of course, have a long history with respect to the closed corporation. We won't bring everyone in on that insight here, or you can if you want. I don't much care. But I wonder, because a lot of your comments focused on sort of opportunities for exploitation, and it seems to me that the closed corporation is sort of the classic opportunity for exploitation. It's an opportunity for exploitation on so many levels, right? Because shareholders don't have an exit right,
Exactly.
because there's huge disparities in terms of bargaining power, because there's these mixed roles, shareholder, but also having an employment position, because of the overlay of family ownership. And it seems like because we allowed freedom of contract early on, we had to make up all of these extra things to protect people that we wouldn't have had to protect if we weren't so happy to accept freedom of contract, like, shareholder oppression.
I don't end up the same place. We certainly had to have freedom of contract because of the deleterious impact of centralized control and majority rule that were seen as crucial to the corporate form. And so we let there be modifications of that, opting out of that, and contracting out of that. But rule number three is, but fiduciary duties for a different reason. It's because of the limits of the human mind. Fiduciary duty is why we don't mandate. We now have a lot more prenuptial agreements than we ever had before, but we don't mandate prenuptial agreements. We still have divorce court. You have to have fiduciary duty because of the inadequacies of what people can, of bounded rationality in the context in which you have to trust the other party to be in business with them. And the optimal answer to that is to keep fiduciary duty, and so to me those two things are not in conflict.
Yeah, they're gap fillers. I mean, that's why we have them.
But you can't opt out of them. If you opted out, you would lower societal benefit from having closely held corporations.
That's one thing I wanted to go back to, and it was raised in Gabe's comments, and that is in this whole discussion about should this rule be mandatory, or should we allow a freedom of contract alternative? It's got to come back to the consequences, either for external people or for the costs at the firm. And Gabe, in your article with Eric Talley, that was central in your discussion about should we, how can we rationalize an exception to the duty of loyalty with this corporate opportunity waiver? And you weren't, in discussing whether it should be permitted, you came back to whether it would be good and efficient, and you came up with all kinds of rationales for that. And it seems like that should be, central for any decision. Like earlier when I was discussing, this broad clause, it's got to come back to, is that going to solve the agency costs? And, and then if so, and what other costs will it create? And, what are the costs for the firm? And so I see that, when we're getting at this issue of the limits on private ordering, it's got to come back to that. What are the consequences for the firm, the costs, and so forth? Because otherwise it seems like an abstract, question. Should we allow this waiver or departure? Should we allow this in private ordering? And yeah.
I completely agree. I think the only caveat I'd add is there's sort of like there are virtues, and I think there's a necessity to approach these at a retail level. Like, you have to think about whether some new potential alteration to the mandatory rule is whether it has potential virtues or not. Nonetheless, I do think Anat and Jill and others, pointed to things that should haunt us whenever we do that retail analysis, which is whether in aggregate we're undermining the structural value of a numerous clauses-like corporate form by picking away at it. So anyways, that's just a way of saying I completely agree that I think you want to say, hey, is there actually a potential efficiency to be gained for firm-specific private ordering through this new contractualization mechanism? Nonetheless, you've got to step back at some point and say, okay, are there also things we may not be picking up when we run our event study because it's becoming more costly or difficult to think about corporate governance as a whole because the system's being.
But that would be part of the whole cost-benefit analysis, that you could take, Jill's concern and sort of say, well, we're going to weigh that against, well, what are the efficiencies that we have as private ordering, but we have to kind of weigh it against, the benefits of having a corporate form. And yeah. And I think that's still part of one analysis.
Gabe, I would turn around your question of a few minutes ago. Why do you think in 1999 they passed that in the form they did? What was different in 1999 from 1989 or 1979?
I think the explanation is that there had arisen a class of major investors whose business model implicated them in investing in natural competitors, right? There were certainly a lot of VC firms and PE firms who were agitating for the change, and I have mixed feelings, and most of us probably do, about those financial actors that do some good things and do some bad things. But I think their view was, hey, we have ownership positions in 3 different electronic commerce platforms. Yeah. If we don't have one in 2217, we're caught up in intractable fiduciary conflicts. We run into a business opportunity that could be of value to one of these 3 firms, or us as an investment fiduciary that might want to receive some 4th option. Now, when we don't know what to do, we're facing a serious duty of loyalty question that doesn't have an obvious answer.
So would it have made sense to limit that provision to a controlling director, controlling shareholder? I'm sorry, a non-controlling shareholder.
Yeah.
Because once you have a controlling shareholder and action by the board,
Yeah.
you got no check.
Exactly, and that's what they're doing.
Yeah.
They're picking the winners, and by the way, in most cases they are controlling the board.
Right.
They are telling the board what to do.
So I'm saying, I'm asking Dave whether it made any sense to have it outside of a non-controlling situation.
So I think here's like a vague doctrinal answer that I think they would push. They'd say, look, there's the prospect of aiding and abetting liability for the firm if a director has a fiduciary conflict. So you can have a minority VC position. You can own 8% of the company, or 12 or 20%. 20% obviously pushing towards controlling territory. But if you own 15% of the company and you've placed a principal of your VC firm as a director on the company's board, and they are subject to the standard duty of loyalty, I think the VC firm would say, hey, we want to be able to cover our bases and say, we are able to direct that individual to not share the opportunity without facing the idea that we've abetted a violation of fiduciary breach. That's one caveat, but other than that caveat, I think that, yeah, what would he, I don't know, it's complex, but I think that line of logic makes a ton of sense.
With that, I have the unhappy task of telling you that we've reached the time to close this panel, and the happy task to say thank you so much, all three of you, for wonderful presentations. It is time to invite Julia to provide some closing remarks to us and ring down the curtain on what's been a great day, I think.
So, okay, what I can say is this has been a fantastic day, exploring the limits of private ordering in the corporate context, and we have so many papers to read and things to think about, and papers to write as a result of this conference. And I'm not going to say anything more than that, but it was really wonderful to have people here and to have people remotely and to meet people remotely, like I met Gabe remotely today. Anyway, so have a great time exploring all the ideas that were generated today, because we're going to have a lot of fun. Okay.
Thank you. We have the focus, and we have a few mandatory. They're there historically for a reason. And they're there.
They cause more problems over time.
So is there anything you want to do to take your cap out?
I know, but there's some things that I'm trying to convince Delaware not to change for that.
When's your